Good morning. Welcome to Long Live Third Parties Podcast. Free Press Media Press Inc., a third parties books publisher, sponsors this podcast. I'm Andrew Bouchard. Today I read the case Matters of Stevens versus Collins, 120 AD 3D 696 NY Appellate Division, 2nd Department, 2014. Friends, the Green Party is popping up again today. So let us examine how they sought to advance ballot access. This case centers around a notary issue. We've run across many different issues in these ballot access cases. I don't remember coming across a notary issue. So let's find out specifically what happened. It says, quote, Natalie J. Collins sued heroin as Natalie J. Collins together with Kevin F. Hagan and Gerald W. Betha Heron, collectively the appellants, filed with the New York State Board of Elections, herein the Board of Elections, a petition for an opportunity to ballot by providing for writing candidates pursuant to election law 6-164 in a primary election to be held on September 9, 2014 for the nomination as the Green Party candidate for the public office of State Senator to the 8th Senatorial District. Michael Vendito as an aggrieved candidate and Ella Stevens and Patricia Woodstock as citizen objectors commenced this proceeding inter alia to invalidate the petition for opportunity to ballot, and the appellants cross-petitioned, among other things, to validate the petition for an opportunity to ballot. The Supreme Court invalidated the petition for an opportunity to ballot on the grounds there was an insufficient number of valid signatures. End quote. The insufficient number of valid signatures is coming up again and again. That's a common reason. That's the main drive that they're using to get people off the ballots. The notary issue comes into play as they're examining the signatures. It says, quote, the hearing testimony of the notary that he in fact authenticated the signatures on sheet 2 in July and that the date marked was an inadvertent mistake did not serve to correct the defect, inasmuch as the time to file petitions with the Board of Elections, as well as the time to amend or correct such petitions, had expired by the time the hearing was held. End quote. Some people would look at that as a minor deal, but the court here did not view it that way. They consider this a deal breaker. As they state, quote, here, since the requirement that the notarial statement accurately reflect the date of the authentication is one of substance, not form, end quote. And they also say, quote, the error in the jurat on sheet 2 cannot be considered merely technical, end quote. So what do you think? Do you think that this error is a minor one they should overlook? Or do you think it is something more pressing? If you've filed ballot access petitions, have you run across issues like this? Have you? It would be interesting to find out. So ultimately, they say no, they're not going to let them get on the ballot because of this mistake. Our friends here deserve credit for making the effort to not only get on the ballot in the first place, but in the second place, to file suit. And because this is in multiple appeals, they deserve even further credit for taking the time, energy, and initiative to fight this. So good job, friends. Good job. Let's keep doing like they did. Long live third parties. Goodbye.